So welcome to the SecureDynamics TechCast. With me today, I have Elizabeth Rogers. I'm going to read out your title. She is the privacy and cybersecurity partner at the law firm Michael Best and Friedrich. She's also the board member at Cyber Houston and chair-elect for the computer and technology section of the State Bar of Texas. Welcome, Elizabeth.
It's a privilege to be here. Thank you.
So I'm going to start off with an article that you wrote, which is really, I think, while you had written it titled Remote Lawyering, the aspects that you brought about, I think, apply to every business which is digital, right? Which is pretty much every business out there today, right? I'm just going to highlight a few things and then we can get into a discussion, right? You highlighted three distinct areas. So let's start with number one, which is privacy and duty of confidentiality. And you talked about separating the electronic space and using encryption, right? So talk a little bit about, I mean, yeah, people are at home and you turn on everything. What does a separate electronic space entail, and how can somebody go about making that uh, uh, making that fence, if you will?
Of course. So thank you for introducing the topic, Ashwin. I think it's relevant and timely throughout 2021 as we are still facing the pandemic and even a new variant, which could delay the return to the workplace in the conventional way that we've known it. So to create a framework that I think will underlie all of our conversation, most regulators and lawmakers are focusing on the standard of reasonable security.
Mm-hmm.
So I want to start off and preface all of my comments by that standard to make a point that in certain cases, it will be considered reasonable only to have encryption and only to have a segregated network for confidential information. In other cases, the information that our professional workforce is dealing with is all public. Therefore, the added steps or the added expense of facilitating encryption may be unnecessary. So with that having been said, and thinking in terms of what is reasonable, it matters about what your data is, right? Everybody needs to know the data that they're dealing with and where does that data live. When you go home to work, if you're not used to that, it's not always readily answered, right?
Yep.
Because you've relied on people either in the enterprise you work for,
Right.
or that duty's been outsourced. But for the most part, a good place to start is to find out if the data you're dealing with is regulated in any way. And some people are unaware. Lawyers tend to have a greater familiarity with what data is regulated and what isn't. But for example, trade secrets are, all over organizations and deserve protection. In academic universities and colleges, there's intellectual property assets that may not be regulated by law, but nevertheless require extra security measures. So an example of one way that people can treat that information with reasonable security is to create a segmented network. And network segmentation can be done at home. Even the most fundamental knowledge of technology allows someone to use an external drive, for example, or a USB drive. And so those are two examples of ways people can segment their confidential data from their data that maybe others in the home have access to on their device. So it would involve creating files and databases on the external drive in which any correspondence, any client documents or customer documents that are sensitive could be stored only on that drive, and that drive or USB would be only accessible to the employee or owner of the company that needs to know the data on that external drive. That's one example.
Yeah. So Elizabeth, just picking that, good segue into the second piece, which you wrote about access control of the data itself. You just mentioned that briefly, which is the USB, access to the USB stick and access to the external drive. Now, again, to your point, this is something that is kind of taken for granted in an enterprise, right? When I think of those old traditional data centers, we actually had physical barriers to even get to the servers. Now with cloud, obviously all that goes away, but you still need access control. But people typically don't think about it in the context of home, right? You talked about a USB drive, like who physically has access to the USB drive, which has critical information. So how do you kind of advise clients to think about, I mean, you talk about zero trust in the enterprise. Is it time to think about zero trust at home?
It's time to transition some of those standards that prevail in the enterprise to the home, because right now they're all one and the same,
Yep.
right? We no longer have separation, compartmentalization. If we are working from home, or some people like to say living at work, the whole focus is blurred. So, the chief information security officer or the information security analyst are terrified now that so many segments of the work population are working from home that never have before. For example, accounts payable or accounts receivable personnel who have traditionally always been at the office now are dealing with highly sensitive financial data of the organization on their home device. And so the standards that prevailed in the workplace, in the brick and mortar location, should be applied in the home, and there should be the same security updates and patches and minimum security controls used at home that were and have been traditionally used in the workplace. And so that means satisfying a checklist, for example, that the home worker is bound by a duty of confidentiality to the company and a duty of care to only allow access to any data that they are using for their work to accomplish their position. Only the worker will have access. And so that may mean creating a new account on the device, such as a Mac, creating a new guest account that only the personnel, employee or owner of the company is able to access. Mm-hmm. Another idea would be that, for example, in a team where there are 3 to 4 people who are helping to manage the project, maybe only 1 or 2 members of that team are given privileges to access the underlying critical data to accomplish the project. There are various ways, and they're still evolving. Unfortunately, this situation did not come with an instruction manual or owner manual, but we're learning and we're getting better. That's the good news.
So talking about something that you and I are on Zoom right now, right? And in the physical confines of an office space, if you're going and talking to your boss and there's something, you're physically going to his or her room, close the door, and you have this quote unquote private conversation. And you mentioned this, right? I hadn't thought about it in those terms, but now looking back, it actually makes sense. You get on a call, like you're my boss, I'm getting on a call with you, and I pretend as if we are in the physical environment where you're not having a conversation, but we're not. We're going over the public internet. Initially, when Zoom started, there was this whole thing about encryption and is it truly end-to-end, all kinds of things. So again, given everything that's going on over here, how does somebody really understand and whose duty is it to say, hey, can we even talk about this on this call right now, right? I mean, how do you make that front and center?
Of course. So if I may, I will illustrate this and provide an answer in the context of being a lawyer, simply because there are other professions, doctors, others that do have the same duties of confidentiality, and perhaps, a company's policy even requires the same, even if it's not by law. So the idea would be that we have so many technology solutions available to us during this remote working environment. They just exploded in 2020. Zoom is a perfect example. It's the poster child of insecurity, but they also did an incredible job of recovering and reforming after being investigated. But the lesson that the Zoom conference platform taught all of us is that technology is way ahead of even security. People often talk in terms of technology being far, far ahead of privacy controls, but it is also ahead of security controls. So it behooves us as consumers of technology and solutions to conduct an robust assessment of the vendor and ask the vendor to provide a list of the security controls that went into development of the software. Oftentimes what happens, as we've learned through the SolarWinds data breach, there are vulnerabilities in the software. And so we can no longer take the security of software we use for granted. So the idea is not to rush into these technology solutions, no matter how many benefits they may promise. The ethical duty of technology competence for lawyers that exist in 38 states requires us to be familiar with not only the benefits of technology, but the risks. And so that cannot be emphasized enough, especially right now. And without trying to indict any particular vendor like Zoom, the whole purpose is to try to help people stay connected. But as you point out, being connected in this environment with so many cyber criminals waiting to exploit the home worker, it is more critical now than ever that we are intimately familiar with the security protocols of any technology solution that is used for connectivity.
So Elizabeth, one final question, right? And this just happened to me this morning, as it's still fresh in my mind. So I went to one of the foremost SaaS providers, and I logged in, and the first thing was this pop-up screen about their privacy practices, right? And I could not go beyond that until I hit OK. It was 18 pages long, and I had to get to my end goal. So even though I talk about tech privacy, and I will go and take a look at it for sure, for me, it was what stood out was if they had just put out, hey, these are the 3 big things you need to know now, right? Versus throwing this out there and pardon my French, it's essentially covering your back to knowing that they've actually made that available to me. I could not have gone forward until I had read it, but I did not read it. I just freaking scrolled through it and hit OK, right? So again, coming back to this notion of, you mentioned ethics, how have you seen forward-leaning companies truly engage with their customers to give them the data that they need to be aware of what they're doing versus putting this 18-pager knowing that no one is going to read it? Right.
That's thank you for allowing me to respond on that particular topic, because it is the answer is based on a principle that underlies the entire foundation of privacy, and that is what companies owe consumers of their website services, such as yourself this morning, is meaningful and informed notice and consent, period. At the beginning of your connection to that particular website and that service on their website, all you need to be told at that moment is, we are collecting X, Y, and Z pieces of data from you. It needs to be a complete and explicit disclosure or notice, and then it should give you the opportunity, or any user, to provide their consent. They're opting in to provide this data once they begin the transaction over the internet. To include all the rest of the controls that may exist, or who the data is shared with, or the laws that may apply that they're following, is not necessary at that moment. Mm-hmm. It needs to be simple, but complete and accurate. And all that you need to do is know that there is a privacy statement you can click on at a later time.
Correct.
To, if you have any questions or you want to inform yourself on a deeper level, that's available to you. But otherwise, it's not meaningful at all to put an 18-page disclosure of the entire privacy statement at the moment you're entering the website. It's unnecessary. All that is necessary is just providing you notice and the opportunity to consent or not.
Great. So I feel more relieved now that hearing from you about that meaningful and relevant information, right? And there are examples of that, right? I use Evernote a lot, and I love the way they put it out there, which is you own your data, we secure your data, we do not sell it to any third parties, right? So that's all I need to know, right? And after that, like you said, I can go and look deeper into how they do it and which provider they use and so on and so forth. So
yeah, before the California Consumer Privacy Act was enacted, we used to joke our clients and say, your privacy policy should state, we are going to collect every piece of information about you and we're going to sell it to the entire universe, period. One sentence privacy policy. But now, as we know, consumers are entitled to control their data, they have rights, and I think we're going in the right direction. So
great conversation, Elizabeth. Good chatting with you, and hopefully we can have future conversations as well.
Yeah, thank you, Ashwin. I enjoyed it. Thank you for having me.